we only have 1 hour, and I want to. There's enough time at the end for questions. And welcome, everyone. I'm Patricia Young. I'm a manager for the Institute for European Studies here at the Radice Center. And I'm delighted to introduce our panel today on transforming the global labor system. First, we have Samira Rafaela. He's a former member of European Parliament, where she served until 2024, and is now a visiting scholar in feminist jurisprudence at the Cornell Law School. She is the first Dutch member of the European Parliament of Afro-Caribbean descent ever elected, and she led major EU efforts on human rights, gender equality, and trade, earning recognition as one of Parliament's most influential voices during her mandate. Chiara Cristofolini is an associate professor of labor law at the University of Trento, Italy, and a visiting scholar at Cornell's School of Industrial and Labor Relations. Chiara earned her PhD in Comparative and European Legal Studies at the University of Trento, and is currently part of the TELOS European Research Project, which stands for Transparency in Employment and Labor Markets for Inclusive Organizations and Society. Sarosh Kuruvilla is the Andrew J. Nathanson Family Professor of Industrial and Labor Relations and Asian Studies, and the Academic Director of the Global Labor Institute at Cornell. His research is policy-focused, and particularly on the linkages between economic development strategies and national human resource, labor, and skills development policies in Asia. He has authored several books and numerous peer-reviewed articles in referee journals, including, most relevant here, the 2021 Cornell University Press book, Private Regulation of Labor in Global Supply Chains. Our panel will be moderated by Chantal Thomas, the Vice Dean and Radice Family Professor of Law at the Cornell Law School, where she also serves as the Director of the Cornell Center for Global Economic Justice and as Faculty Director for the Clark Initiative for Law and Development in the Middle East and North Africa. Professor Thomas holds a PhD in law from the University of Cambridge and a Juris Doctor from Harvard Law School and a BA in Political Science from McGill University. Professor Thomas has authored more than 50 articles and other publications on aspects of international economic law and development. She has consulted for the United Nations, USAID, and the World Bank, and advised numerous US government bodies, and is a life member of the Council on Foreign Relations. Big thank you to all of our panelists for taking the time to come here to the Radice Center and share their insights with us on this important topic. And I will now pass it to Chantal to briefly introduce our topic. Yeah.
Thank you so much. I'm so delighted to be part of this conversation. I always love coming over here, coming across campus and out of the law school and into this very interdisciplinary and international space. It's always really generative and important. In the law school, I think an important effort is always to situate the law in its social, political, and economic context. So to understand not just law on the books, but law in action. And that's very critical to understanding the possibilities, prospects, and perils that might confront any particular set of legal issues or legal reforms. And this question of labor and labor in the international trade or international economic context is so critically important and so difficult and challenging for so many reasons, many of which certainly are well situated and grounded in the social and political and economic context. So I know we just have a very short time, and I want to get into our very distinguished presentations. So I think Samira will start us off. I'll invite everyone to give their presentations, and then I'll try to lead off with a few questions for discussion, but we really welcome comments from you and are looking forward to a good discussion. So with that, Samira, please.
Thank you very much for the introduction and also for the invitation to have me here. It's a great pleasure to be back here in Ithaca. So I would like to start indeed with the EU Forced Labour Regulation. So I have the privilege to be the lead negotiator in the European Parliament for the EU Forced Labour Regulation. It is, I think, therefore important to understand the context of it. So before I start to explain about EU forced labor regulation, I always quickly go through the EU institutions, the process, EU legislative decision making. It's a complex process, but as you can see here, we are dealing with three institutions. So the European Commission has the so-called right to initiate a legislative proposal. Then it puts forward the proposal, and then the co-legislators, the European Parliament and the Council, are going to negotiate about the proposal, of course, together with the Commission. And then, as you can imagine, we will negotiate about a compromise and outcome. And to understand the EU forced labor regulation and the context, it is important that the European Union for years already is having many debates about how to strengthen its strategic autonomy and its economic position in the world, and also to make sure that trade is value-based, that it's rules-based. So throughout the years, we have seen different legislative proposals, policies, programs being put into place to strengthen trade policies, but mainly to make it more fair and also more competitive. So more rules, also to safeguard and protect the values that we in the European Union find so important. So obviously the EU forced labor regulation is part of that. That is, I believe, within that context of wanting to have a more value-based, rules-based trade. So what we are seeing is that we are going from a voluntary to a mandatory regime. The topic of forced labor is a huge problem. Almost 28 million people worldwide are a victim of forced labor, but that's only the registered cases. I mean, let alone the non-registered cases. We know that it is a significant problem, and that it is a problem in the private sector, but also even on a state level, and something needs to be done about it. So what happened is that the European Parliament was also one of the institutions that demanded a specific instrument, a specific tool to fight forced labor, and especially as being the European Union, as a promoter of human rights in the world, you will need to have a solution against this problem, as this is breaching human rights. So it's going against international human rights law. And if you look at the statistics, companies do earn a lot. It is a business model, unfortunately, we can say. So it is really about solutions that target these perverse incentives. And that is what the forced labor regulation will try to do, but I will elaborate on that. It is adopted in November 2024, and then December 2024, we finally reached the end stage. So that means that it's finally going into force, and that the implementation of this regulation can be prepared. And then hopefully in December 2027, we will have a working forced labor regulation. So that means that it can actually be triggered and can be used for the EU market. And it's an instrument to ban the products made by forced labor. So it's not about services, also to be clear, it's about banning the goods that are entering the EU market. So we are trying to ban forced labor and ban these products within the European Union, but also outside the European Union. And what is strong here, of course, that's always strong about EU legislation, but at the same time also complex, is that there are 27 member states that will need to do the same, and that will need to enforce also the same. And these member states are going to work together, exchange information to make sure that the product is just not entering the EU market. So a product that is banned in this member state will also be banned in this member state. That is really the power of the EU market. And of course, we will foresee international cooperation, because if we want to fight forced labor on the global stage, Of course, we would like to see two super economic powers, and that is the US and the European Union together to see what they can do to fight forced labor on the global stage. So just to give you also some perspective, was there already existing EU legislation? Yes, there was, of course. So you can see this forced labor regulation also as complementary to what already was in place. For example, it has a link, of course, with combating human trafficking, but also, of course, the directive on sustainability, corporate sustainability due diligence directive that was that was approved, but there's a lot going on there. We will get to that. So what are the key aspects of the forced labor regulation? First of all, it is a market surveillance instrument, again, banning these products from the market inside, outside the European Union. And we're trying to do that in the first place through an investigation that is evidence-based, and that has different phases. I would say two phases. So there is first a so-called preliminary phase in which a request for information will be put forward when a complaint has been filed. So it can be a complaint by anyone, by any organization, or it can be self-triggered by the competent authority based on evidence that they've got, for example. And then you go into this investigation, and then the evidence will be judged and will be analyzed. And then a decision will be made about whether they are going to continue with the investigation or not. And there needs to be a so-called substantiated concern. The evidence needs to be objective, it needs to be verifiable, and then they will continue with the investigation. But another key aspect is the database. I think it is very strong that this forced labor regulation has a so-called risk-based approach. So also to inform consumers, companies, stakeholders about the high-risk areas, the high-risk products, the high-risk sectors. That information will all come into a database, also with specific attention to state-imposed forced labor. And also, of course, about the bans. So you will, in this database, you will learn about the bans, but not ongoing investigations. So there will be no information on ongoing investigations, only if it showed forced labor and the ban was put into place. And then, yeah, of course, lastly, the strongest aspect is that it cannot enter the EU market when forced labor has been found. And also for the investigation and to make a decision, what are we going to investigate or not? That's a risk-based approach. So, for example, they will look at the severity of the case, the volume of the case, to decide what has priority in terms of investigation. So here a bit more on the risk-based approach. Like I said, to prioritize based on skill and severity. I've mentioned it, so there will be a single information submission point where stakeholders can actually submit a file or a complaint. And furthermore, there will be guidelines that are still in development. So next year, summer, we expect the database and the guidelines also to be published so that companies can learn and understand what they will need to do exactly to implement this regulation. So when it comes to the investigation, just to give you a summary, it starts with triggers. Here you see the triggers. Then a preliminary phase, request for information. Within 30 days, an answer needs to be given. And then an investigation based on substantiated concern. And then decisions can be made. So, for example, in order to withdraw the products, in order to dispose the products or replace them, that's also possible. And then enforcement, when it comes to enforcement, you can imagine that the customs will play a very crucial role in enforcing and monitoring under this regulation. So when it comes to the EU forced labor regulation, we need to keep in mind that it's, first of all, a product's risk-based approach. And during the negotiations, of course, we had a lot of dialogues and discussions about the lack of a workers-based approach. And I think that is really the future of the forced labor regulation. Just to make you aware of the fact that the topic of remediation was absolutely not in the initial proposal. It's really the success of the European Parliament that got the topic of remediation introduced in the forced labor regulation. So also for me as a lead negotiator, it was a huge win, a significant win that we got the topic of remediation introduced. But of course, if you would say, is the workers-based approach in the forced labor regulation sufficient at the moment? It's not. But what we did get was a definition of remediation, so understanding of remediation, also as part of the guidelines. So there will be guidelines and information on what companies can do to remediate. And also as part of the investigation, questions will be raised about remediation to the companies. And lastly, a strong point that we got is that remediation and also the introduction of a remedy mechanism will be evaluated. So for the next evaluation, the topic of a remedy mechanism will be part of it. And then there will be a new judgment on whether this should be part of the forced labor regulation. So I see that there is hope and that there are opportunities for a workers-based approach under the EU FOR. Then lastly, on the topic of international cooperation, that was also a very important article for all the stakeholders, because you can imagine that on the global stage, this needs exchange. It needs exchange when it comes to the kind of sources, the database, the information that is already available. So there will also be a forced labor union network in which this kind of exchange will take place, also about best practices, for example, on the topic of technology, best practices for traceability, for example. But definitely also when it comes to international cooperation, I believe that this network should be the place where policy experts in the transnational space, for example, will meet each other. So when it comes to specifically the cooperation with the United States, it might be of interest to you. Like, okay, what are then the main differences here? Of course, I believe that what the United States already had in place was sometimes part of the discussions also in the European Parliament. Of course, we needed to look at that because there are a lot of interesting lessons, I believe, that we can learn. But for example, there are differences in the scope of application, the specific use of LPA that is focused on the specific region that it needs to target. That we don't have under the EU forced labor regulation. We don't work with the so-called rebuttable presumption, but we do, for example, work with the high risk list, where we indicate the geographic areas at risk of state-imposed forced labor, for example. So these are differences in approaches. Like I said, the burden of proof is different than there if you don't work with rebuttable presumption. When it comes to the lists, for example, the EU LPA entities list, but under the EU FOR, we work with the database. But there's no mentioning of entities and companies in the publicly accessible database. And then when it comes to evidence, for example, what can trigger a WRRO under US regulation, that is reasonable suspicion. But here, for example, under the EU FOR, we work with the definition of substantiated concern. So you do see that there are differences in the definition of evidentiary standards. And of course, when it comes to enforcement, where you see that member states and the European Commission will investigate. And also in the US, you see differences with that. So just one point on enforcement, when the forced labor case is within the European Union, then the member state is responsible for investigation. If it's outside the European Union, the European Commission is responsible for the investigation. We called that the so-called 28th authority to investigate during the negotiations. So I would like to go to the end, just to give you an impression of negotiation phases. This was literally the last night of the negotiation on the EU Forced Labor Regulation. That's how it goes. And we had a lot of support, I believe, the so-called Brussels lobby that really called upon the European Parliament and the other EU institutions to approve this forced labor regulation. And press conferences we had, one more time the council, of course, that needed to approve. And then there it was, the EU law in 2024, it was signed. So we are now looking to the phase, the phase in which the EU forced labor regulation will be implemented. But the last note that I would like to make, Europe is moving to the right, and Professor Kuruvilla will definitely say something about the current developments concerning CSDDD. And what I am concerned about is that this is affecting labor rights, as less regulation and legislation will be put into place, and therefore also less safeguards for labor rights. And this is a challenge that we are facing, as we are seeing that now with the omnibus package and the CSDDD. So I will leave it here. Thank you.
Bring down to. Thank you very much. I'll probably stand, otherwise I cannot really look at my slides. So thank you first of all for the invitation. The aim of my very short presentation will be to discuss the European forced labor regulation, but from a specific perspective, but from a specific angle. That is the impact of the forced labor regulation on the global labor system, and therefore the impact of the European forced labor regulation on the protection of the international labor rights. From this perspective, I would say that the major strength of this regulation is the fact that the European regulation does not endorse, let's say, a European notion of what forced labor is, but rather endorses the definition provided by the International Labour Organization, by the ILO, by referencing the two ILO conventions on the forced labor, Convention number 29 and Convention number 105. Now, this might look and might seem like a minor detail, like an insignificant detail, but instead it has significant consequences, significant implications for the global labor system, and I'll try to explain why. First of all, by adopting the definition provided by the ILO, so by the International Labour Organization, the regulation, the EU regulation, links itself to the ILO's framework, so to the ILO's standard setting system. The ILO, the International Labour Organization, is the institution competent for protecting the international labor rights. But most importantly, is the international organization competent for establishing and protecting the so-called core labor standards, from the abolition of child labor to the protection of health and safety in the workplace. However, the ILO has often been criticized as being the so-called toothless tiger, because the ILO has no direct sanctioning power, has limited enforcement powers. There's no such thing as an international labor court, for instance, at the international level. And what the ILO can do is basically just recommend its 187 members to impose economic or political sanctions on the member states that violate the ILO conventions. So much so that throughout its institution, and the ILO was built in 1919, we only have two cases in which the ILO invoked sanctions. We have one case, this is Myanmar in the 2000, and the second case is most recent, is the one of Belarus in 2023. Here is, I believe, where the European regulations
can make the difference, can fill the sanctioning power gap, because it provides a relatively strong sanction, which is the import and export ban on products made with forced labor. What we could say, it provides the sanction on import-export ban on products made in violation of Convention number 29 and Convention number 105. Because again, the notion of forced labor is that adopted by the ILO. With this, so adopting the definition provided by the ILO, the European regulation also strengthened the ILO framework, the ILO core labor standards, at least the, let's say, second core labor standard, the one on forced or compulsory labor. Just to make you an example of what I'm trying to say and I'm trying to explain, let's take the Chinese example. China has ratified the 2 ILO conventions on forced labor in 2022. And last year, in 2024, the International Trade Union Confederation filed what we call an observation against China, alleging the widespread use of forced labor in China, not only in Xinjiang, but also in other regions, such as Tibet region. Of course, the ILO has requested China to respond to the allegations, and most importantly, has required China to provide evidence of the measures taken to address the issue, to tackle forced labor in China. However, it is unlikely that the ILO will take the step of imposing economic or political sanctions on a country as powerful as China. However, these violations can now be tackled by the European Union, by the European institutions that can rely on the ILO documents, can rely on the ILO cases to demonstrate the existence of forced labor practices in China, and therefore maybe leading to the adoption of the import-export ban on Chinese products entering the European market. So here is where the European regulation fills the sanctionary gap, providing against the violation of Convention number 29 and Convention number 105, a powerful tool, a powerful economic tool. However, of course, this regulation has also weaknesses. And one of the weaknesses is that the forced labor regulation does not provide remedies for the victims of forced labor. We do have, as Samira highlighted, references in the recitals of the regulation, but there's no provision, so there's no legally binding provisions on remedies. For instance, the regulation does not require the companies to compensate the victims of forced labor as a condition for lifting the ban. What the regulation does is only, let's say, blocking the goods from entering the European market. These and other weaknesses of the regulation have led some scholars to say and to argue that we are not really dealing with a human rights approach or human rights measures, but rather we are dealing with a protectionist measure. Let's say the idea behind the regulation is to protect the European market, to protect the European enterprises from cheap products, especially from cheap products coming from the developing countries, because of course, a product made with forced labor is usually also a cheaper product than those free of forced labor. However, I do not really agree with this argument, and I'll try to explain why. Again, moving from the ILO definition of forced labor. As also Samira was saying, we are dealing with a regulation on products. So it's not a regulation aimed at protecting the victims of forced labor. And you can see that from the legal base. The legal base is composed of all provisions that are market related. The recitals, let's say, the social dimension, let's say, is more relegated to the recitals. However, in my view at least, it is not a product or an example of the so-called old-fashioned protectionism, such as the Trump tariffs that we are witnessing right now, we are experiencing right now, because it's not built on the protection of the national interest or the national enterprises, or the national sovereignty. Again, the reference is the ILO. So what the EU regulation is doing is requiring the states and the enterprises to abide to international standards, not European standards, to abide to and protect one of the so-called core labor standards that are universally acknowledged human rights protected by widely ratified conventions. So what the regulation is doing is, in reality, let's say, protecting the ILO core labor standard, one of the ILO core labor standard, through the market. And the vision that is pursued is that the global market should not only be free, but also fair. And if we look the regulation from this perspective, I believe we can say that the regulation is only one example of a broader picture, of a broader European effort to, let's say, protect and advance the ILO core labor standards through the European market policies. On the slide here, you have some other examples: free trade agreements, the general system of preference plus, the latest EU conflict minerals regulation. And some of these initiatives have already had, let's say, an impact. For instance, in 2021, South Korea, that has stipulated a free trade agreement with the EU, finally decided to ratify 3 ILO conventions, 3 ILO core conventions. Convention number 87 on the freedom of association, Convention number 98 on the right to collective bargaining, and the Convention number 29 on forced labor. So, if this is the case, so if my understanding is correct, I would say that rather discussing whether this is a human rights approach measure or it's a protectionist measure, whether it aligns with the market interest, the European market interest, what we should discuss about is whether this approach is effective. Is strengthening the connection between 5 core labor standards and market regulation the solution? If it is so if it is the solution, for instance, should we discuss about extending the import ban to protect the other 4 core labor standards? Let's say child labor, for instance, or freedom of association and the right to collective bargaining. This is the case of Canada. For instance, the Canadian legislation does not only target the forced labor, but also the child labor. So I think that this discussion that we should have, and maybe we can discuss it later, is not rather about, again, protectionist rather or human rights approach, but is this effective or not? I have my view, but I would like to first learn yours and then maybe discuss on that.
Okay, so we talked about 5 core labor standards, 5 human rights. You get to choose only one to attack. What would you choose? Can we go around the room quickly? It's freedom from child labor, freedom from forced labor, freedom from discrimination and gender-based violence, freedom of association, collective bargaining, and the right to a safe workplace. Pick one.
Freedom of forced labor.
Child labor, whatever.
Safe workplace.
Child labor.
Child labor.
Freedom of association.
I was going to say freedom of association because it can deal with all the other things.
An enabling right.
Thanks for it.
The association.
Child labor.
Okay. So you can see there are differences, right? So how come we've only moved in the direction of forced labor and through using economic leverage that, you can't sell your products in our country if it's made by forced labor. Why can't you do that for child labor? And that is an interesting question because for some reason, the US had these laws since 1930 about forced labor. And the political thing about, and the EU also started these laws in 2011. All of them, these laws got new life breathed into it by the Uyghur Labor Prevention Act in the US in 2020. one, right? It became sort of really easy to sort of convince all kinds of parliamentarians on the right and the left to sort of agree to this kind of solution to the forced labor problem. With regard to all of the others, we have to remember that we did not have an international system of regulation that could hold companies accountable for what they did in their supply chains in other countries. That was left to national governments. And in the context of supply chains, those national governments did not enforce their own laws. And this is what spawned what we call private regulation, where companies were trying to enforce the five labor standards on their suppliers, right? And this, those of you who've been around long enough know of this in the 1990s as Nike and the sweatshop campaign and right, students against sweatshops, etc. That launched a private regulation program that forced Nike to and Gap, etc., to have private regulation to sort of have a code of conduct which they expected their suppliers to follow. Now we have 25 years of that, and by and large, there's a lot of agreement that private regulation, getting companies to regulate their supply chains by themselves, has been a failure. Right? And so, for the first time, the European Union enacted a new series of laws 2 years ago called CSDDD, the Corporate Sustainability Due Diligence Directive, and the Corporate Sustainability Reporting Directive, both of which required companies to sort of do something. One is to report on what they do and how this affects their financial results and what is their impact on the environment and human rights. And the other one is to actually do due diligence, which means create plans to prevent and remediate human rights violations throughout their supply chain. Okay? So the day that was passed, I drank an entire bottle of wine by myself because I said, look, this is what we needed. We needed to have voluntary doesn't work. Now we have a mandatory system, and the mandatory system has teeth because aggrieved parties from anywhere in the environment, Bangladeshi workers, for example, can sue the European company in the European courts for the first time. Earlier, international law, we used to have laws here too. I mean, like the Bhopal incident in India, you couldn't sue in the US because it was always forum non-convenience. This is not the right place to sue. You should sue in India where the thing occurred. Now the CSDDD gives these aggrieved parties the right to sue in European courts, and that was worth an entire bottle of wine that I drank. Okay, but so for the first time, you have something about all five, not just one, right? But then soon after that was passed, a couple of months later, European Parliament elections were held. People like Samira left the parliament, and you have a new, very right-wing parliament that seeks to gut this law completely, right? And so they introduced what they call the omnibus bill. Last year, it has been wending its way through this complicated European governance system of commission introduced it. The council and the parliament have discussed it, and there is a tentative agreement that not only takes the stick away, that is the right to sue, civil liability, takes that stick away. It also makes this law applicable to a very small set of companies. It delays the introduction for a couple of years, and then it only sort of focuses on the first tier of the supply chain and not the second tier, the third tier, and modern slavery and the cotton farms where all the clothes come from. All of that's completely gone. So that this big effort to handle all five is now effectively failed. Do we have anything left? Yes, we still have the trade agreements. And, the US has free trade agreements with several countries. The EU has free trade agreements with several countries. But the labor clauses in it for the rest of the five, for all five, are pretty weak. In some cases, you sort of say, yes, you have to ratify the ILO convention, but countries ratify ILO conventions, but don't necessarily implement them. So, it's not a big deal to sort of say, hey, they ratified the convention. The US has ratified very few, but we have on some issues, we are actually better than others. On some issues, not all. Okay, and then we have free trade agreements in the US with several countries, all the labor side provisions of that. The basic idea is, hey, you want to access our markets, you need to follow good labor standards. But the language is very weak, and our ability to sort of really sanction a country from sending its goods here because of lousy labor standards is very limited under our free trade laws. Okay, so we don't have that much left. And then we know that the Uyghur law is kind of, it's selectively implemented. So if you look at the goods that are stopped on the US customs border today, right, most of them are not from China. But the Uyghur law is particularly about forced labor in China from Xinjiang province. But most of the goods are from Malaysia, followed by Vietnam, followed by Thailand, followed by China. So we have more than 3-4 billion stopped from Malaysia, and we have 0.42 billion stopped from China. So what's going on here? Because there's re-export. China produces it, sends it off to Malaysia. Malaysia sends it off here. And when we catch on to that, then we will have Zimbabwe, and we will have somebody else, exporting stuff to the US, right? So, given this loophole, and given the right-wing shift, not only there but in our country as well, I am not expecting big things as the forced labor regulation actually gets implemented, because there will, in all of those cases, there will be efforts to water it down. Especially, you have to remember that their law, the EU's law, is much tougher than ours. Here, under the UFLPA, they just hold the goods until you can prove that the goods were okay. But if the EU system, once they find that you're violating the law, you actually have to go and pull your goods from every shelf in the supermarkets. It's a really big, tough deal, and we think companies are going to stand for it. They're not. So they're going to fight it at every level, and they will fight the implementation, but they have 2 years to do that. And so I'm expecting bad news there, just as we have heard the bad news just last week on CSDDD. That's all the 5 that they've agreed to. They haven't announced it yet, but we've reached agreement. So I'll stop there on that lousy note.
This is really so rich and informative. And now it's my job, I guess, to try to draw out a couple themes and maybe ask some questions. And we only have 15 minutes, and we want to leave some time too for at least a little bit of discussion. So let me try to be brief, but let me raise a couple of themes and questions, and maybe try to pose a question to each of the speakers. So I think in general, probably most of us, in this room are very supportive. Very few people would be, against overall a ban on forced labor. It's a good thing to do. Most of us understand the challenges in global governance, right? The challenges with effective implementation of global norms and standards, the absence of a central authority that can exert coercive power against, even signatories to international treaties, problems of gathering information, etc. So these are really innovative and I think inspiring reforms. And they're occurring in, at the same time, a very kind of contested and controversial environment. There are always these critiques. So let me try to draw out one of the questions. I think it came up in Chiara and your presentation that is often raised is, well, is this a form of disguised protectionism? So this is a very typical objection to labor or other kinds of social linkages to trade that, and it's, it's very frequently coming from the global south, that this is just a way for the rich countries to keep, their market share. They don't want us to be competitive. So they're putting these bans and they're calling it labor rights or human rights. And this is a reason why at the very beginning of the World Trade Organization, its very first big meeting, there was a movement by developing countries to get the WTO to adopt a declaration specifying that labor can be a form of competitive advantage. And they wanted to do that because they wanted the whole membership of the WTO to say, having cheap labor is a market advantage. It's not inherently wrong. We need you to say that because we're trying to push against a kind of stigma or an insinuation that if you're competitive and you're cheap, producing cheap products, it's because you're engaged in forced labor. And in that same meeting, there was an agreement that all of the labor questions should be dealt with in the ILO and not in the WTO, right? So now, what was that? What do we do with that? What do we make of that? Is that a tenable statement, or is that simply, the sort of the developing countries trying to argue against the incorporation of or the integration of this particular norm in a trade context? Well, let me just make a couple of other observations here. I mean, it's interesting that the forced labor provision that you mentioned in the Tariff Act of 1930, the Tariff Act of 1930, otherwise known as the Smoot-Hawley Act, you may have read about if you're a student of trade history, is notorious for being the high mark up until now of US protectionism. So it had, the highest ever levels of tariffs, is sometimes, blamed for accelerating global depression because of that, et cetera, et cetera. What do we make of the fact that among the things that the Smoot-Hawley Act did was it included this ban on forced labor? Is that a data point that suggests that it could be a form of disguised protectionism or not? Okay, maybe, right? So there's that controversy. However, my own view is that even if it is a form of disguised protectionism, that doesn't mean that it's a bad thing, because actually it's still establishing norms that are, that are potentially going to be, it's still helping to implement those norms, and that's potentially going to be a very good thing. But if it is disguised protectionism, one of the issues there, though, is that it might be a reason why you don't have the political will to see better implementation. So, because actually the goal is not to eradicate forced labor, but it's just to sort of gain some market advantage. So here, one question, maybe I'll pose this to maybe to Samira, would be why in your work on bringing about this very historic reform, was there discussion about whether the forced labor ban should look inwardly and be focused on domestic labor abuse in addition to import ban? As Chiara mentioned, the focus is on stopping products that come into the market. But I ask you this because you noted that a kind of related piece of legislation was sanctioning employers related to their employment of workers who are in an irregular situation. So in other words, irregular, like labor migrants. And that is a situation that lends itself to labor abuse and very coercive labor circumstances in countries in the global north. And that's true here. So even like a few miles from here, right, we have dairy farms that employ migrants from Central America and Latin America, and many of whom are in an undocumented or irregular situation. Our farm worker clinic at the law school helps, some of them. And very often, their passports are withheld. They are situated in kind of isolated spaces. There are very coercive labor circumstances that occur in countries in the global north. And so I guess the question is there a possibility for thinking about the issue of forced labor in our own markets in addition to thinking about it as a ban? And here I'm trying to kind of suggest that one data point in the argument that it's disguised protectionism is that the strongest tool for implementation is the import ban, as opposed to other forms of rooting out forced labor. So I guess that's maybe a question if this ever came up, or if it ever was an issue, or if it's something that you might envision going forward. As kind of related question would be, so maybe a more updated version of the disguised protectionism objection would be, this is all about geopolitics. And this was, again, you mentioned in your presentation that maybe this is about not just preventing competitive cheap products from coming into our market, but also from preventing the rise of rival powers like China. And so it can't escape observation that the updated version of the Forced Labor Protection Act was the Uyghur Act, which is focused on a province in China. And then the notable application in the EU, even though it's not limited to China, but it got applied to China very quickly. And so you might say, well, what is that telling us? You might say, well, that's because there's a lot of labor abuse in China, but maybe it also suggests that there's a kind of geopolitical dynamic here. And I guess my question for Chiara is, I wanted to ask you if you had any views on this anti-coercion instrument that the EU has adopted recently. So this is an instrument that the EU adopted to guard against what it called the weaponization of trade. That it can use it against, for example, the US, because of the various things that the Trump administration is trying to do. But I thought this was very interesting because the suggestion is that using trade to try to get other advantages or other policies to support other policies is a bad thing. But it seems like the idea of trade sanctions is doing exactly that. And so this is maybe an unfair question because you didn't present on it, but I wanted to ask you maybe if you had any thoughts on that. And then I guess my last question would be, again, on the implementation point, that the focus is on border measures, and that the opportunities for really looking at company level enforcement and implementation are much more difficult to come by. And so I guess for Sarosh, I wanted to ask you to elaborate a little bit more on what you think it would take to really build political will amongst the corporate sector to take this on board, and kind of in your own work looking at the indicators that you've developed and sort of the monitoring piece, what would be required to have a more robust sort of full-fledged form of implementation? So obviously I'm trying to be provocative here. I thought I would just throw out a few questions. And maybe just for time, let me see if there are any questions from the audience, and then we can just ask folks to respond to any of them that they want to. But does anybody else have any questions or comments?
Okay. I have a response to some of the discussion about that. Is it protectionism or is it not? I don't think there's really, I can understand internationally why the EU as well as national governments would try to show or prove in some way that it's not protectionism, although it seems like it's politically more viable to actually use protectionism as an argument for strengthening these free trade agreements. So I do wonder if some of the domestic politics can affect the feasibility of strengthening these kinds of labor protections on the basis of different combinations of protectionist versus global labor standards more altruistic, and we care about solidarity and conditions in other countries kind of logic and arguments. And I'm thinking about how it's not usually so much of a binary. I remember going to a big Wandel rally in Germany where IG Metall was holding politicians to account in Berlin, saying, we need fair, what is the English word for fair Wandel is like, just transition. We need a just transition to environmental goals. And if we in Europe are going to have very strong regulations that are going to increase our costs, and our companies are investing in something that's for the international global common good, then we have the right to also protect ourselves from cheap imports that will undermine that. So this logic of protecting markets is also a way of not just saying we're being protectionist for the sake of some narrow sense of common of interest, but rather that we are representative, we're enforcing these standards, we're trying to create a more kind of fair and just economic system domestically, and that also gives us the right to constrain exit of capital to cheaper products and goods elsewhere. So I guess it's the question of whether, I suppose one part of that is whether the political logic can change as we have the far right gaining power, and how that might influence how those discussions are held. And then on the other hand, thinking about perhaps the role of the labor movement in bringing some of that domestic argument away from the dichotomy of national versus international interests.
Following on the political question, I also just think that markets are complex, and I find myself wondering, I'm really curious to know, maybe especially from Samira, who your allies are in Parliament. And my kind of guess, and this is why I kind of want to confirm with you, is that you actually have very strong allies from sectors that are very threatened by products made by forced labor internationally. So I think there would be very good reasons for both capital and labor representing certain sectors in the European Union to sort of support this kind of program, both for humanitarian reasons, but also to protect their own products domestically, their own kind of workers domestically, their own capital interests domestically. So I don't know if that's true, but I'd be curious to know kind of who are the allies in this kind of programming internally.
Who were the allies?
Thank you. Yeah.
They're not there.
Maybe there are new allies with different logic and arguments.
Thank you for a great presentation. Well, I just maybe switching topics a little bit, but I would be curious to know the panelists' opinions and envisioning. So if Sarosh, and it's true that the top-down kind of governance mechanism, the ILO standards, the mandatory due diligence, and the trade agreements are not efficient to eradicate forced labor, what do we think about bottom up? And Samira talked about how the forced labor regulation doesn't really have strong workers approach, but we do have some examples of worker-driven corporate social responsibility, like the Dindico Agreement, the Lesotho Agreement. So what do we think of that as a possible solution, and how can we foster that and scale that to a global level?
This is wonderful. So it's 1 o'clock.
Yes.
But we were literally out of time, but maybe you guys could each take 1 minute to say something that you could try to respond to, broadly, but don't feel like you have to respond to individual questions, including mine, but maybe just a final thought from each of you. So starting with Samira.
Yes, thank you very much. Yes, I've been in the International Trade Committee. I very much believe, and I've seen it with my own eyes, that if we negotiate trade agreements in a way that can work for workers, then trade agreements can be effective. So yes, I think it's all complementary to each other. Is it protectionism in some way? I think it's always protectionism in some way. The question is, what are you trying to protect? Is it fair for the European Union to say we want to protect our market from these kind of projects projects that are breaching human rights, I think it's fair to say that. Is it fair for the European Union to say, hey, we want our business also to be competitive because they are losing ground, because they are competing against these markets and businesses that have cheap models through forced labor? I think it's fair for the European Union to say that. So it's always some form of protectionism. And you know, that's why we also have incorporated Article 13 international cooperation, so that there is exchange also with the global south and developing countries to see how we can assist them, because we have learned from other kinds of legislation where actually that criticism was really present and saying, hey, you did not listen to the needs and worries of, for example, developing countries while making this type of legislation. So I think this is also stronger about the EU FOR. It's an import and an export ban. So yes, it's going to fight forced labor within the borders, but also outside the borders. So I think it is not really fair to say that, you know, this in some way has been an instrument to fight other markets, but yes, to fight the type of production that is breaching human rights in general. I mean, that has been the main request also of the European Parliament. Is it geopolitical? It always has an impact on geopolitics, always. I mean, of course, it is in light of strategic autonomy. It is in light of competitiveness that will do something with the geopolitical ties and also the diplomatic exchanges even, I believe. So the investigation is really key on the EU FOR to stay objective and to stay neutral, and also to prevent other member states, for example, to have a different kind of agenda that might impact the result, speaking about geopolitics. So the investigation on the EU FOR is really key. And then who were my allies? You know, I think in general, I've seen allies from different kind of sectors, even the companies and sectors that you might not expect it. So I think in general, the allies were the ones that agree that you cannot continue to breach human rights like this. And there are a lot of companies out there that understand that it improves their reputation and brand. So they understand that this is actually making you a better competitor in your sector, also because of the consumers' demands. So I have seen support throughout sectors and brands and companies. There are some sectors that you might not see, but yeah, we all know who they are. So yeah, that's a summary of my.
That's great. Hopefully we can all, people who are interested can just stay in contact or email our speakers, but yeah.
No, just building on what Samira said, I think that the discussion sometimes to me seems that protection is a synonym for protectionism. And in my view, we really do need to pay attention on what we are protecting. And my idea of linking at the international level is precisely that. It depends on what you are trying to protect. I also think that this discussion on protectionism versus free trade is based on, let's say, the US model rather than the European model, because there's also a difference between how the EU is signing the free trade agreements and how the US is signing and putting forward these strategies and policies. It is only the EU that has ratified the conventions and then also asked the other countries to do the same. Of course, the US has not ratified many of the convention and then, however, require the other member states to abide to those conventions. So there are different approaches, and I think that the risk of this kind of discussion is to let's say remain in the superficial and not look at the content of the provisions and what kind of rights we are protecting, because these are specific type of rights. We could say public policy, public security, but in the end is workers' rights, human rights acknowledged, universally acknowledged and not European standard. And this is, to me, the key difference between what is protectionism and what is protection.
I just want to say one more nuance is if you look at the USMCA, which has protectionist policies in it, like, requiring Mexican factories to pay 3 times the average wage, so that some of these factories would come back home. But it also has asks Mexico to improve its own labor law enforcement, which is actually good for Mexican workers. So it is complex.
Yeah.
I think that what would I like to see, given this whole rightward shift and the failure of, top-down instruments, if there is more transparency, if we can at least require transparency, which is what the CSRD does, then that gives lawyers like her and others a chance to sort of fight these in the European courts. So we should require more transparency. And on the bottom-up side, unfortunately, they're nice. It sounds good, but they're often not scalable. I just published on my website the Dindigul Agreement, first formal evaluation of it, which is the official one they asked me to do. And it's a wonderful agreement, but it is a doomed success. It's a success in that one factory, and a success because the number of different things, hyper-local reasons make it successful. But can it be scaled? And the answer is no. So scaling is the problem. Oh.
I think with that, we have to close, but thank you so much for the wonderful presentations.